Discuss the practice of judicial review and judicial activism in India. Answer: Judicial review is a special power of the Supreme Court and High Courts in India to scrutinize whether a law passed by the legislature or an action taken by the executive is in accordance with the provisions of the Constitution or not. If it is found that such a law or an action not in accordance with the Constitution, then it can declare them as invalid or unconstitutional. This means that the judiciary has to act as the guardian or custodian of the Constitution. The Supreme Court and the High Courts can exercise this power on two conditions: whether the law or the executive action which has come under security falls within the competence of the authority that has framed it, and whether it is consistent with Part 3 of the Constitution dealing with the fundamental rights. The concept of judicial review originated in the United States of America in the Marbury 5 Madison case of 1830. The power of judicial review has made the Supreme Court of America one of the strongest judiciaries in the world. In India, the Supreme Court, while exercising its power of judicial review, has to follow the principle of procedure established by law. Article 21 of the Indian Constitution provides that no person shall be deprived of his life or personal liberty except according to procedure established by law. Here, the term law does not mean natural law, but it means state-made laws. In other words, the court can only question the procedure, and if the procedure is not followed, the court can declare any legislation made by the parliament as unconstitutional. The Supreme Court of India has limited power of judicial review. Still, it has been able to exercise this power effectively in many cases and protect the provisions of the Constitution. Judicial activism. In India, the judiciary has been given the power to protect the Constitution and to preserve the fundamental rights of the people. It has been empowered by the authority of judicial review, and in that capacity it has been exercising its power in recent years, which is dubbed as judicial activism. Under judicial activism, the court has begun to intervene in the question the activities of the executive and the legislature, reminding them from time to time of their duties and responsibilities to the society. The beginning of judicial activism in India could be traced back to 1985 when the then Chief Justice of India, Justice P.N. Bhagavati, converted a letter written to him on a est card by an aggrieved person into a public interest litigation. By the middle of the 1990s, judicial activism became more and more pronounced. The activism of the Supreme Court became visible in terms of sensitizing the Control Bureau of Investigation (CBI) to discharge their constitutional obligation in the Howler case, in which top-level political personalities were involved. It has passed landmark judgment over environmental degradation, pollution control, preservation of historical monuments, eviction of unauthorized occupation of government buildings, etc. In this way, the judiciary has become overwhelmingly busy with cases brought before it from various quarters of the society, and the activism of the Indian judiciary has benefited the common people in terms of addressing their grievances to a large extent.